Hello everyone. A very good afternoon to all of you. Welcome to the Officer Adda channel of Adda 24/7. So this is your BRBL subject in the English medium language. You can easily see that our victory batch is going on, in which the paid class is going on. Okay, so in the paid class you can see here all the subject is already started. My subject, I'm your BRBL mentor. The timing of my subject is 7 to 8 p.m. So this is very important, okay, because this batch is very important. After that, you know that from April onward, right, your registration will be start. So I think after registration, there will be no time, okay, to study. So that's why if you want to finish your syllabus before the registration, so I think this batch is the best one that will give you the full chance to crack your exam. Okay, because in this batch, we are giving you the live classes, we are giving you the recorded session, we are giving you the mock paper and the doubt session, etc. Okay, so that's why if you want to enroll in this batch, you have to apply the coupon code Y391 for the maximum discount in this batch. Okay, and if you want to purchase the bilingual batch, so the bilingual batch is a Jeet batch. You can take the Jeet batch by applying the same coupon code in this session. Okay, so this is important. Now let's understand the thing. So today class we are going to study the questions of Company Act 2013. Okay, questions of Company Act. So basically in the Company Act we have to study the features, we have to study the types of company, then what is memorandum of association and article of association, then some doctrines we have to study. After that, features, type, doctrines, and then after we have to study about the director, then prospectus, okay, and your member. So these are the topics in the Company Act that we have to study. So we do not have to study this Company Act whole. So the previous act was 1956 and now this is 2013 act. So this is again important from the examination point of view. Is that okay? Now let's do the question. Number one question on the screen, that what is the minimum number of person required to form the public company? 1, 2, 5, 7. Tell me class. And in this question I will tell you the whole thing about this one. So tell me what is the right answer for this question. This is very important. By this question you will get to know the member of every company. So for this thing, the right answer will be C. The minimum number in public. So first of all, we have to understand the private and then the public. If we talk about the private, minimum, this is maximum. Okay. So minimum 2, minimum 7. Maximum 200, maximum unlimited. So this is the minimum number of person to form the public company. So the right answer will be public company. First one, D is the right answer. So this is important for the examination point of view. Okay, this one. So you have to learn all the minimum and maximum. If we talk about the one person company, because this company is introduced in 2013 Act. So the minimum is 1, maximum is 1. So this is again class important. Is that okay? Done? Now, the next one. Which new type of company was introduced in the Company Act 2013? One-person company, two-person company, LLP, and the public-private partnership. Tell me the right answer. Which new type of company was introduced in the Company Act 2013? What is the right answer? Which new type of company was introduced in the Company Act 2013? One person, two person, LLP, and the public-private partnership. That is important one, because we know that before 2013, okay, 1956 Act was there. Act can never be stable. It have to be changed. Okay, Act can never be stable. It have to be changed. So for this question, the right answer will be, that is the one-person company. Okay, for the second one, A will be the right answer. Done? A will be the right answer for this question. Okay, next. What is the maximum number of person to form a public company? Maximum number of person required to form the public company. 50, 100, 200 or unlimited. What is the right answer? The maximum number of person required to form the public company. 50, 100, 200 or unlimited. What is the right answer? The maximum number of person required to form a public company is basically, that is unlimited, because right now we have just discussed it. Okay, so for the third one, 4 is the right answer. Done? Next. What is the minimum number of directors required in the case of private company? 1, 2, 3, 4. What is the minimum number of directors required in the case of private company? 1, 2, 3, 4. Directors. Now, this is very important if we talk about the directors, right? So in the directors again, private company, public company, one-person company. So in the private company, minimum, maximum. This is minimum, maximum. So the minimum is basically what? Minimum is 2, public 3, this is 1. And the maximum in all the company will be 15. So this is the right answer. Is that okay? So the minimum number of directors required in the private company will be 2. This is the right answer. So these questions are very, very much important to form this. Okay. Now, next one, maximum number of members in the private company in the Company Act. C class. We know that in your, this time in your BRBL subject, okay, this time without option questions will become. Without options. So that's why in the without options, these types of question will become, in which the answer should be in the this number form. So the maximum number of members required in the private company will be 200. So for the fifth one, C is the right answer. Is that okay? So this is the right answer for this question. Next. Which one of the following is not the content of the Memorandum of Association? Name clause, register clause, object clause, board of director clause. So in this statement, we know that the important document of the company is memorandum of association and your article of association, right? So in the memorandum of association, basically, if we see, so there are 6 clauses. So in the 6 clauses, the number one is your name clause. Second is object clause. Then register clause, name, object, register, that is the liability clause, capital clause, and the sixth one is your, that is association clause. Okay, so these are the 6 that is important. Okay, so which is not, so I think you get the right answer, that is D will be the right answer. Okay, D will be the right answer for this question. Next, Turkin rule is related to which doctrine? Ultra-vires, constructive notice, indoor management, subrogation. So if I highlight the subrogation, so I think subrogation is the topic of Indian Contract Act. This is the topic of Indian Contract Act. That is a subrogation. Is that okay? So in the subrogation, basically when the principal, debtor, creditor, this is surety. So when the surety pay money on the behalf of principal debtor to the creditor, then the surety can demand money from the principal debtor. That is called subrogation. Ultra-vires, beyond the power. Constructive notice, company is, sorry, in constructive notice, suppose if a company have given document to the outsider. So outsider have to know everything about the company. That is called constructive. So the company is not liable. But in indoor management, if company is changing anything and they are not informing the outsider, so in that case, the company is liable. So the Turkin rule is basically C, that is the indoor management. Okay, what is this? This is the indoor management. Okay, class. So I think this is clear to all of you. Now, XYZ Limited is a having 15% share capital held by X Limited, 50% held by central government. It means this is 15% X Limited taken, 50% central government, 10% state government, and 25% other person. So what this company will be called? Government company, private company, public company, or dormant company? What is the right answer? So for this one, the right answer is A is the right answer. Okay, now the doctrine which advocate the fact that company cannot act beyond the scope of its memorandum of association. What is this? Doctrine of constructive notice, indoor management, ultra-vires, or intra-vires? Ninth one. What is the right answer? The doctrine which advocates the fact that company cannot act beyond the scope of its memorandum of association. Beyond. So the right answer will be ultra-vires. C is the right answer. Okay, that's next. Company Act was repealed by Company Act 2002, 210, 13 and 15. Repealed. It means we know that with the technology that act has been changed. So what will be the right answer for this question? So for this question, the right answer will be, that is Company Act. Okay, next. Which of the following is not true? Not true. Company is artificial person created by law. This is right. Company can do every act like natural person except the act which is purely of personal nature. A company can be held liable for the violation of statutory provision of the Company Act. The company can be imprisonment for the violation of such provision which attract the penalty. How can it be imprisonment? So we have to tick mark on not true. So D will be the right answer for this question. D will be the right answer for this question. Okay, so this is the right answer. Which of the following is not characteristic of public company? Not. Separate legal entity, yes. Perpetual, yes. Common seal, separate property, yes. Its shares are not transferable, no. So this is not true. D is the right answer. A and B were only member of company who died in the road accident. So in that case, the company will come to end. True, false, partially true, partially false. Company will end. The answer is no. Why? Because the company have a separate legal existence, so the company cannot be shut down. A company being a legal person is also citizen under the Constitution of India. That is true, false, partially true, partially false. Which of the following is the right answer? A company being a legal person is also a citizen under the Constitution of India. Constitution of India. That is absolutely legal person. No, that is not a citizen because in the Constitution of India we have a several rights and duties. So it is false. Company come into existence when memorandum of association signed by the number of member. Memorandum submitted for registration. Registered under Company Act, establish its registered office for the functioning thereof. So what is the right answer for the 15th question? The right answer will be, that is C is the right answer. Okay class? Welcome to the Officer Adda channel of Adda 24/7. This session is very much important, in which we are just doing the questions of module D. As you know that module D is very much important. Okay, so you have to focus on the module D questions, because right now we have done the questions of Indian Contract, Sales of Good Act, Partnership Act, Company Act, and today we are going to do a very important act for the examination point of view. So that's why, if you are new in this session, so myself, Advocate Nikita Singh, I'm your BRBL mentor. Okay, so if you want to crack this exam, so whatever the session that we are taking, you have to enroll in that session. Okay, now let's start with the session. So before starting this session, this is your victory batch. As you can easily see that in the victory batch, we have a in the victory batch we have a live classes, recorded session, PDF, mock paper, ebooks, etc. So this victory batch, you can just take the class in your home, because that should be the live class. You can see the recorded session of live class, etc. Okay, so that's why this batch is very much important. Okay class. Now let's understand that what we are going to study. The question and the thing that we are going to discuss is the thing of Transfer of Property Act. So what exactly the Transfer of Property Act means? Okay, this is important. So first of all, TP Act is basically deal with the immovable property. Okay, so in this act, we have to do what? We have to focus on the movable. We have to focus on the sale of immovable property, lease of immovable property, actionable claim, and mortgage of immovable property. So these are the things that we have to study in the module D of the TPL. Okay, in the Sales of Good Act, that is basically deal with the movable property, but in TP Act, immovable. And in this topic, the mortgage word is very important. In the mortgage, we have to understand, in the mortgage topic, we have to understand the types of mortgage. That is important. Okay, so basically, we have to study this one. Now, let's move toward the question. The question first is, can a minor become transferor of immovable property under TP Act 1882? Minor, yes, no, depend, none of the above. Tell me, can a minor become transferor of immovable property under the TP Act? Minor. We know that TP Act basically, if we are transferring the immovable property, that also comes under the contract. So in the contract, when we know that what is competent, what is competent to contract? So competent to contract is basically plus 18, sound mind, and not disqualified by law. So minor become transferor. Transfer means the person who transfer the property. So minor can become transferor. The answer is absolutely no. Because if minor is not able to do the contract, so minor cannot become the transferor. So for the first one, this B will be the right answer for this question. Is that okay? That's good. Which of the following mortgage can be made without writing? Equitable mortgage, English mortgage, simple mortgage, or usufructuary mortgage? Which of the following is the right answer? Tell me. Which of the following mortgage can be made without? So there are 6 type of mortgage in the TP Act. Equitable, English, simple, usufructuary, then conditional mortgage, and anomalous mortgage. Anomalous mortgage. So there are 6 types of mortgage. So which type of mortgage is made that is without writing? So without writing, we know that this is called equitable mortgage. So equitable mortgage is also known as mortgage by deposit of title deed. Mortgage by deposit of title deed. So in the equitable mortgage, basically that is done in the metropolitan cities. Okay, this is the equitable. So in the metropolitan cities, this type of mortgages happen. The next one, this is done without registration. Otherwise, in every mortgage, there should be registration. In this mortgage, there should be intention to give the title of the property. So this is the basic theme of the equitable mortgage. So A will be the right answer. Okay, next. Where principal money secured is 100 and upward. So the mortgage other than deposit of title deed can be affected only. It means we are not asking the question of mortgage by deposit of title deed. We are not asking. So what will be the right answer? It is registered instrument signed by mortgagor, attested at least 2 witnesses, and all of the above. What is the right answer for this question? So, except mortgage by deposit of title deed, it can be affected only by register signed by mortgager, attested at least to witness, all of the above, all of the above. So D3 is the right answer. Next. Under TPA Act, which of the following mortgage in the value of 100 and above is not compulsory registrable? English mortgage, mortgage by deposit of title deed, simple mortgage, conditional. This is also known as equitable mortgage. This is also known as equitable mortgage. So what will be the right answer for this question? Not compulsory registrable. So not compulsory registrable, that is mortgage by deposit of title deed. Which of the following properties can be transferred under the TP Act? The property that can be transferred: salary of public officer, right to sue, both A and B, neither A nor B. What is the right answer? Tell me. What is the right answer for this question? Which of the following property can be transferred under the TP Act? So the property that can be transferred, first of all, if a salary is given to the public officer, so it cannot be transferred to the any other person. So this cannot be transferred. Right to sue. If I have a right to sue, so I cannot transfer it to the another person and I will say that please transfer. This is not happening. So neither A nor B we can transfer. So for the fifth one, D will be the right answer. Next. Now you have to tell me which of the following is true, which of the following is false. That is important. Okay, true and false. That is very, very much important. Done class? Now, first, TP Act basically contained the provision relating to the transfer of movable property and goods. Tell me. Very good question. Hanji class. What is the right answer? So for this thing, TP Act is basically contained, that is false. Okay, now mortgage is a transfer of interest in the specific immovable property to secure the payment of money given by the way of law. This is the definition of mortgage. So that is the right one. It is a transfer of interest in a specific immovable property to secure the payment of money given by the way of law. Mortgage, that is a transfer of interest in the specific immovable property to secure the payment of money given by the way of law. What is the right answer? So this is absolutely true. Okay, now in the simple mortgage, I think by doing this question now, you will get to know all types of mortgage. So in the simple mortgage, the mortgager does not deliver possession of the mortgage property to the mortgagee. True and false, tell me. Simple mortgage. If you know the terms, you can easily do the question. Tell me, class. In the simple mortgage, this is absolutely right. The possession is not given. So in the simple mortgage, the mortgager does not deliver the possession of mortgage property. This is absolutely true. Okay, right. Now the next one is mortgage by conditional sale. In the conditional sale, the one document is there. The document contain mortgage deed. The mortgage deed will be automatically converted into a sale deed if the mortgager is not able to pay the money. So this is the quality of conditional sale. So in a mortgage by conditional sale, the condition of sale is that on default of payment of mortgage money on the certain date, the sale become absolute. Tell me the right answer. Tell me, class. This is the right answer. So we know that in the conditional sale, everything is in the everything is in the single mortgage. So this is absolutely true. Next, in usufructuary mortgage, that's a very good question, sir. Very good question. Usufructuary, English mortgage, mortgage by title deed. This is lease, etc. So in the usufructuary, the mortgager deliver the possession of mortgage property to the mortgagee. In a usufructuary mortgage, the mortgager deliver the possession of mortgage property to the mortgagee. That is true and false. So for this question, the right answer will be deliver the possession. That is true. Okay, because that's why in the usufructuary, if in the usufructuary, if suppose the mortgager have delivered the possession, so if the mortgager is not able to pay the money now, so the mortgagee can take the rent and profit from this. Okay, now in the English mortgage, the property is transferred absolutely by a mortgager to the mortgagee with a condition of retransfer. That is absolutely true. Deposit of title deed, the property given as mortgage has to be situated in the notified town. That is Kolkata, Mumbai, etc. That is true. A lease from year to year or any term exceeding 1 year can be made by the transfer of possession. No, it should be in the registered form. That is false. That is absolutely false. And the debtor has given notice of transfer of actionable claim. Debtor has to be given a notice of transfer of actionable claim. The answer is no. Okay. Hello everyone. A very good afternoon to all of you. Welcome to the CIB channel of Adda 24/7. So guys, this session is very much important because right now we are doing the module D questions, right? So as we know that in module D, basically we have to study the 9 acts. Okay, in module D, basically we have to study the 9 acts, in which we have just completed the Indian Contract Act, we have just completed the Indian Partnership Act, then SOGA Act, then TP Act, and right now we are going to start the RTI and your IT Act. So these acts are very, very much important for the examination point of view, right? So before starting this session, I would like to highlight that this is our victory batch, which is already started from 13th of February. Okay. So if you want to enroll in this batch, because in this batch you will be, the live classes will be there of all the subject. After live classes, you will get the recorded session. Suppose if you are not able to see the recorded session, live session, you can see the recorded session. After that, you will get the mock paper in this batch. Then you will get the mock paper, recorded session, live session, doubt session. Anytime you can ask the session, and there is an official telegram group. In the telegram group also you can ask the doubt here, and you will get the ebook. So these are the things that you are getting in this one. But in this batch, you will get only the fourth compulsory paper, that is your ABM, AB, FM, and BRBL, and your BFM. Okay, so you will get only these things, right? So if you want to enroll in this batch, you have to apply the coupon code simply, that is Y391 for the maximum discount. So this is the single paid batch. For applying this coupon code, you will get the discount. And for elective paper, you have to purchase, uh, the recorded session of the particular video course. So the recorded sessions are also there. You can just take this recorded session. Okay. So, and if you want a complete thing, because we know that your exam is going to be start from the July. Okay. So this is very, very much important. Now, let's start with the module D. So today, RTI and IT Act. So what exactly this act means, we have to understand. So if we see that RTI, so RTI is basically right to information. We can just ask the information from public authority, from class public authority. Okay. So this is the basic theme of this one, right to information. So, we cannot ask question from the private authority. We cannot ask question from the private authority, but we can ask question from the public authority. So public authority includes state as well as center. Okay. So this is important one. So module D is basically, you can see here. Done. Now, suppose if we are asking any question, so why you have a right to ask question? Because we know that we are the people who just vote the people, and then only our government come into picture. So the real authority, I can say you, the real authority and the real power is in the hand of the person, is in the hand of the people. So that's why we can say that in India, the supreme law is basically in the hand of the people. The people are the real authority. So that's why we can ask question from the public authority, so that the transparency and accountability will maintain. Is that okay? And now then the IT Act. So IT Act, we know that we all are in today's scenario that is depend upon the technology. We all are depend upon the technology. So in the technology, you can see here in the, if we just talk about the technology, so basically technology is nothing but whatever we are doing in any area, we need now a digital thing, just like the computer, laptop, etc. So in the bank also, now we all are depend upon the technology. So that's why if any defect will come in the technology, this act is there. Okay, now let's do the question. Number one question. What is the time limit to get the information under RTI Act 2005? It is 15 days, 45 days, 60 days, or 30 days. What is the right answer, class? Tell me. Haji class. What is the time limit? Suppose if we ask any question, right? So what should be the time limit so that we can just get the answer? Tell me, class. That is so simple, important. So class, for this question, the time limit to get the information under RTI, that is 30 days. Okay, suppose if X person have asked the question from the Delhi Education Department, right? So whatever the question he have asked, within 30 days, they have to give the answer. Okay, so the right answer will be first one, D is the right answer. Okay, D will be the right answer here. Next, what is the time limit to get the information concerning the life and liberty of a person? What is the time limit to get the information concerning the life and liberty of a person? Suppose if a police officer, if a police officer detain, if a police officer detain any one person, so in that case, what should be the particular, hour or days under which the police have to give the information, whether it is 48-hour, 24-hour, 5-day, or 10-day? What is the right answer? Tell me, class. Tell me. In the normally, we have a 30 days. But in this case, what will happen? So class, if a person is, suppose if a police have detained any person, okay, so it means that is a basically violation of the life and liberty of a person. So in that case, okay, within 48 hours, we have to, the police authority have to give the information. So 48 hours is the right answer. Next, what is a fee for getting information under RTI? Fee. It is 20, 50, 100 or 10 rupees. What is the right answer? So class, for this question, the fee will be basically 10 rupees. Okay, D is the right answer. Now, Indian citizens have right to information because why? The judgment of Supreme Court say implementation of international law by Indian government. All state adopted agree to implement the act and the law passed by Parliament of India. Which of the following is the right answer for this question? Tell me. The question is very simple. What is the difference between citizen and people? Citizen means that is the Indian citizen, okay? And people, the person who are living in India. So person include both citizen as well as the people. So what is the right answer, class? Indian citizen have right to information because that is the judgment all states. What is the right answer? Yes, class, what will be the right answer for this question? Indian citizens have right to information because what? The question is very simple. Tell me, class. Indian citizens have right to information because that is basically the law passed by the parliament. D is the right answer. Okay, so this is the right answer for this question. Okay, now, how many types the public authority are there? The first option is central public authority, state public authority, both, and none of the above. Tell me. Tell me, class, what is the right answer? Okay, how many types of public authority? So for this question, the right answer will be that is both central and public authority. Okay, next. The long title of RTI Act seek to promote the following qualities in the working of every public authority: transparency, punctuality, efficiency, or reputation. What is the right answer? Yes, class. How long RTI seek to promote the following qualities in the working of every public authority? So it is basically for the transparency. This is the right answer. Okay, next. Next question is, what are the component of IT Act 2000? Legal recognition of digital signature, regulation of certificate authority, digital certificate, and all of the above. What is the right answer? So class, for this question, the component of IT Act is all of the above. D is the right answer. Next. IT Act 2000 amended the various section of which of the following act? IPC, Reserve Bank of India Act, Indian Evidence Act, and the Bankers Book Evidence Act, or all of the above? What is the right answer? Tell me. What is the right answer for this question? So class, when the IT Act come into picture, right? When the IT Act come into picture, IPC changed Reserve Bank of India, Indian Evidence, Banker Books Evidence. So that's why D is the right answer. Next. What is the maximum penalty for damage to the computer system, unauthorized access, download of data, infecting with virus, denial of access as per section 43? It is 50 lakh, 1 crore, 5 crore, or 75 lakh. What is the right answer? Hanji class. So guys, for this question, the right answer is 1 crore rupees. Okay. Next. Order passed by controller is challengeable before High Court, Cyber Appellant Tribunal, Adjudicatory Officer, or Supreme Court. What is the right answer? So guys, for this question, the order passed by controller is challengeable before the, it's a Cyber Appellant Tribunal. Okay, this is the right answer. According to section 78 of IT Act, a dash shall investigate any offence under this act. Tell me. A dash shall investigate any offence under this act. What is the right answer? What is the right answer for this question? The right answer will be, that is police officer, not with the rank of inspector. This is the right answer, okay? This is the right answer for this question. Done? Next. The officer designated by public authority in all the administrative units and the offices under it provide the information to the citizen requesting for information under this act, known as what? Appellant authority, chief information commissioner, public information officer, or assistant public information officer. What is the right answer? The officer designated by public authority in all the administrative unit and the offices under it provide information. So that should be done by the public information officer. Which of the following items may be disclosed under suo motu? Suo motu means by itself. By itself, disclosure under section 4. Is it information related to the procurement, foreign tour of Prime Minister, and the transfer of policy order, and all of the above? Tell me. That is very good question. That is very good question. What is the right answer? Suo motu means by itself. Okay. By itself. So which of the following item may be disclosed? Information related to the procurement.
Hello everyone, a very good afternoon to all of you. Welcome to the Officer Adda channel of Adda 24/7. A very warm welcome to all of you. So today in this session, as we know that the module wise questions are going on and we are doing the questions of module D. So now let's start with the module D. First of all, before starting, I would like to say you that this is your victory batch, which is already started from 13th of February. In this batch, the session is going on. The session is going on in which the live classes is there. After that, recorded session is there. Okay. Recorded session, then the mock paper, ebook. So many things are there in this victory batch. So if you want to join, you have to apply the coupon code, that is Y391, for the maximum discount. Because this is the batch in which in the detail form you will get the things. Okay. Now let's start with the next one. What? In today's session we are going to do the questions of Prevention of Corruption Act. So Prevention of Corruption Act, what? This is basically in the banking sector also the corruptions is going on. So that's why in the module D this is the part of your syllabus. Okay. Now let's do the question. Number one question. Which among the following is the correct with regard to the Prevention of Corruption Act? This act is to consolidate and amend the law relating to the Prevention of Corruption Act. It extends to whole of India. It applies to all the citizens of India outside India. It means the citizen who are the Indian citizen, but they are just going outside. So on that person also this act is applied. So you have to tell me which of the following is the right answer here. Tell me class. This is again very, very much important. Which among the following is the correct one? Correct one. Hanji class. First of all, what is consolidate? Consolidate means to combine. Amend the law relating to the Prevention of Corruption Act. Extend whole of India. Apply to the all citizen of India outside and all of the above. So for this question, the right answer is D. Because all statements are correct in this one, Prevention of Corruption Act. Okay, now the next one. What is public servant which is defined under the Prevention of Corruption Act 1988 means? First option, any person in the service or pay of the government or remunerated by the government by fees or commission for the performance of any public duty. Second, any person in the service or pay of a local authority. C, any person in the service or pay of a corporate established by or under the central, provincial or state act or an authority or a body owned or controlled or aided by government or a government company as defined under section 617 of Company Act, and the D is all of the above. So which of the following is the right answer for this question? Tell me, guys. Public servant. You all are public servant. Tell me. You all are, guys, public servant. So what do you mean by this term? That is important. Hanji class. What is the right answer for this question? What is the right answer for this question? So for this one, the right answer is public servant. So the public servant is D is the right answer. Okay, because see, that is remunerated by Government of India, pay of a local authority, and this one aided and controlled by the government. So that's why for all these things, D will be the right answer for. Okay, next one. Under section 3 of the Prevention of Corruption Act, the central government or the state government has power to appoint as many special judges to try the following offences. So first of all, you have to remember the central and the state government have power to appoint what? To appoint the special judge. Tell me. So there are three options. The first is any offense punishable under Prevention of Corruption Act, any conspiracy to commit or any attempt to commit or any abatement of any of the offense specified in the act. C, both A and B, and D, none of the above. What is the right answer? Because we know that we people have a normal court also, right? We people have a normal court also, but we people have a normal court also, but under the Prevention of Corruption Act, there is a special judges that is appointed to handle these cases, and that is called special judges. So special judges is appointed by which authority? I will tell you whole thing. So first of all, tell me this one. Any offense punishable under the Prevention of Corruption Act, any conspiracy to commit, any attempt to commit, or both A and B, or none of the above. What is the right answer? So here, any offense punishable under this act, any conspiracy to commit or any attempt to commit, or both A and B, or none of the above. So for this question, the right answer will be, that is C is the right answer. Both A and B is the right answer for this question. Okay, both C is the right answer for this question. Next. A person shall not be qualified for appointed as a special judge under the Prevention of Corruption Act unless he has or has been. Before solving this question, I would like to say you that there is a civil cases and criminal cases. Okay, so what is the difference between civil and criminal? Civil cases means case between private versus private person, and in this one the one party is always state versus person, right? State versus person. In the civil cases, you know, in the civil cases, the punishment is always in the form of compensation and settlement. Okay, and in this one, the punishment is always jail or life imprisonment, etc. In the civil cases, right, if we see, the lower court is called district court. Lower court is called district court, and in criminal case, the lower court is called what? That is session court. Okay, this is a lower court means, first of all, the case will be come in session court. Suppose if I talk about the criminal case, if any murder and theft is done, so first of all, the case will be handled by the session court. After session court, high court, then Supreme Court. In civil, district, high court, and then this one. So in the session court, the judges who handle the matter, that is called session judge. And this is district judge. This is district judge. Okay, so what is the right answer? What is the right answer for this question? So the person shall not be qualified for appointed as a special judge. In this case, the right answer will be session judge is the right answer. Okay, additional session judge, assistant session judge. So either A, B, and C. This is the right answer. Okay, this is the right answer for this question. Next. Offence punishable under Prevention of Corruption Act shall be tried by special judge of CBI court, special judge of NIA court, special judge appointed under Prevention of Corruption Act, or all of the above. What is the right answer? बताइए. Tell me, class, what is the right answer for this question? Tell me. Offence that is punishable under the Prevention of Corruption Act shall be tried by what? Special judge of CBI court, special judge of NIA court, special judge appointed under Prevention of Corruption Act, and all of the above. What is the right answer? So for this question, class, the right answer is, this is the right answer. Next. Every offence under the Prevention of Corruption shall be tried by the special judge for the area within which it was committed, the area within which offender reside, the area within which the complainant reside, and the case is decided by the governor of respective state. That is very good question. Tell me, class. every offence under the Prevention of Corruption Act shall be tried by the special judge for what? The area within which it was committed, the area within which the offender reside. Offender means the person who have done the crime. The area within which complainant reside, and it is decided by the governor of this. So guys, every offence under this tried by the area within which it was committed. So for sixth one, A is the right answer. Is that okay? A will be the right answer for this question. When trying any case, the special judge may also try an offence other than the offence specified in Section 3 of the Prevention of Corruption Act, with which of the accused may under IPC, Code of Criminal Code, Code of Civil Procedure, and all of the above. Tell me the right answer. Tell me the right answer for this question. When trying any case, the special judge may also try the offence other than the offence specified in Section 3, with which the accused may under Indian Penal Code, Code of Criminal Procedure, Code of Civil Procedure, and all of the above. Tell me. IPC, it is an act in which the definition of offence and the punishment is given. Code of Criminal Procedure, Civil Procedure, all of the above. What is the right answer? Civil procedure, in which, the civil cases handled by the civil procedure, criminal cases handled by the CRPC. So in the Prevention of Corruption Act, basically this. So B is the right answer for this question. Okay, B is the right answer for this question. Next, the trial of an offence under Prevention of Corruption Act shall be held as far as practicable on day-to-day basis, and endeavour shall be made to ensure that said trial is concluded within the period of 6 months, 1 year, 2 year, and 3 years. This is a very important question. Tell me, class. The trial of an offence under the Prevention of Corruption Act shall be held as far as the practicable on the day-to-day basis, shall be made to ensure that the said trial is concluded within the period of 6 months, 1 year, 2 year, and the 3 year. See, class, first of all, minimum 2 year, extend up to 6 months, but not more than 4 years. So this thing you have to remember. Okay, 2 year, 6 months will be the extension, and extension cannot be exceed 4 years. So this is the right answer for this question. Okay, next. Where trial under Prevention of Corruption Act is not concluded within the 2 year, the term among the following action can be caused. The special judge shall record the reason for not having done so. The set period may be extended after recording reason for the period not exceeding 6 months at a time. Set period together with such extended period shall not exceed only 4 years in aggregate, or all of the above. What is the right answer? The right answer will be C is the right. No. Exactly. Class, all the above is the right answer. Judge have to give the reason. It can be extend 6 months at a time and not exceed 4 years. So all of the above is the right answer. Okay, all. Next. A person conducting the prosecution before a special judge under the provision of Prevention of Corruption Act shall be deemed to be the what? What is the right answer? Amicus curiae, special prosecutor, public prosecutor, or assistant solicitor general? The right answer will be here. So, public prosecutor, because public prosecutor, we can say that is a government lawyer. Okay, government lawyer is the right answer. So 10th one, C is the right. Okay, C will be the right answer. Hello everyone, a very good morning to all of you. Welcome to the Officer Adda 24/7, the special session of your BRBL subject in the English medium language. So before starting this session, I would like to say you that this is your BRBL victory batch, okay, in English medium, which is already started from 13th of February, okay. So if you want to enroll in this batch, you have to apply the coupon code, that is Y391, for the maximum discount, because in this batch the various subject is going on, okay, of all the 4 subject. So if you want to enroll it, you have to use this coupon code, because right now the discount is going on. In this batch you will get the live classes, okay, you will get the live classes, then after you will get the recorded session. In this session you will get the mock paper, you will get the ebooks, doubt session, etc. So that's why this is very, very much important for the examination point of view. Okay, now let's do the questions of LLP, limited liability partnership. So this is the part of module D. Before this we have already done module A, B, C, and right now the D is going on. So in the D we have generally completed all the acts. Okay, so this act is also very much important. So limited liability partnership act is nothing but it is a combination of your partnership plus what? It is a combination of partnership plus, you know, the features of some company act is equal to LLP. This is the basic formula of LLP. So we can say that LLP is the hybrid of, okay, LLP is the hybrid of partnership and company. So basically the main thing of partnership is to do the business. Company also, the main theme of company is to do the business, and for LLP also the main theme is to do the business. So this is the basic formula of the term LLP. Okay, now let's start the session. Number 1 question on the screen is that which of the following is the true about LLP? What is true about the limited liability partnership? Okay, so the LLP is not a distinct entity from its partner. LLP is a legal entity separate from its partner. C. LLP is a body corporate, and the D is both B and C are correct. So tell me class, if you have done this LLP, then this question is very, very much easy. Hanji class, what is true about LLP? Okay, tell me. LLP is not a distinct entity from its partner. LLP is a legal entity separate from its partner. LLP is a body corporate, and both B and C is the correct one. Tell me the right answer for this question. This is very easy question. Okay. Tell me guys, ma'am is live, okay? Hanji. The first thing is LLP is not a distinct legal entity. This is absolutely wrong. Why it is wrong? Because LLP, you know, the features of company, that company have a separate legal entity. So LLP also have a separate legal entity. So the first point is absolutely right, right? Second, LLP is a body corporate. This is also right. So that's why for this one, the right answer is B and C is the correct answer. Okay? B and C is the correct answer for this question. Is that okay? Done, class? So you have to learn this feature of LLP. LLP is a legal entity separate from its partner. LLP is a body corporate. So both B and C is the right answer. Okay, if you have any doubt, you can please ask in the comment box. Next question. Which of the following is true about the number of designated partners required in the LLP? So this question is about designated partners. Okay, now the first option is LLP can have at least 2 designated partners. B, LLP can have at least 3 designated partners. C, 7, and D, that is a 4 designated partners. So which of the following is the right answer? Yes, class, tell me which of the following is the right answer. Always remember in LLP, there is a minimum 2 partners, maximum, and designated also. So 2 will be the right answer. A. LLP have at least 2 designated partners. So second, A is the right answer. Is that okay? So this is the right answer. Done, class? So you have to tell me the answer for this question. Now the next one. What is the exact time limit, okay, under which LLP must file its annual return? So this quality of annual return is basically of company. So just like company have to file the annual return. So same thing, they have to file the annual return. So LLP must file its annual return within 30 days. LLP must file annual return within 45 days, within 15 days, or within 60 days. What is the right answer? Tell me, class. What is the right answer for this question? These questions are also very much important. Tell me the right answer for this question. What is the exact time limit under which LLP must file its annual return with the registrar? So the right answer will be just like company, A will be the right answer. Okay. Third, A will be the right answer for this question. Done? Next. Every LLP must maintain its book of account diligently. What is diligently? That is due care. Those book of account should maintain what? Particular of receipt and expenditure at LLP with the detail of those transactions, an inventory of the cost of goods purchased, work in progress, inventories, finished goods as well as the goods sold, a complete record of the assets and the liability of LLP, or D, that is all of the above. What is the right answer? Again, I will say LLP is nothing but it is the hybrid feature of your partnership firm and the company. Tell me, class. LLP must maintain its book of account. So they have to maintain the first point, particular of receipt and expenditure, and inventory cost of goods purchased, work in progress, the complete record of assets and the liabilities of LLP, and all of the above. Tell me, what will be the right answer here? So for this question, the right answer will be, that is D is the right answer. Okay, D is the right answer for this question. Next. The next question is that which of the following is the designated place where LLP should maintain its account? So the LLP should maintain its account at the branch office. Second is corporate office. Third is head office. And the fourth is registered office. Which of the following is the right answer? Fifth one. Tell me. Which of the following is the designated place where a LLP should maintain its account? Which of the following is the designated place where LLP maintain the accounts? We know that LLP, just like the company, they have to maintain the accounts. They have to maintain the accounts. Okay? Tell me, where is the place? So class, for this question is the right answer will be D is the right answer. Okay? At the register office, they have to maintain the account. Okay? Next. Next question is, which among the following parties in LLP should sign the statement of account and solvency? Tell me, what is the right answer? Which among the following parties in LLP should sign the statement of account and solvency? First, it should be signed by designated partner authorized on the behalf of LLP, signed by one partner authorized on the behalf of LLP, signed by all the partners of LLP, and signed by at least two partners authorized on the behalf of LLP. Which of the following is the right answer? Tell me, class. Which of the following parties in LLP should sign the statement of account and solvency? Tell me. It should be signed by designated partner authorized on the behalf of LLP, signed by one partner, all the partners, and at least two partner authorized on the behalf of LLP. What is the right answer? Yes, class. Which among the following parties of LLP should sign the statement of accounts? So for the accounts, whatever the thing that is related to the legal one, it should be signed by the designated partner. So for this one, the right answer will be A will be the right answer. Okay. And always remember in LLP, minimum 2, maximum that is unlimited. Okay. And if it is less than one partner, then still they can continue the business. And designated, there should be the 2 designated partners. Okay. Now, next one. The LLP should file its statement of account solvency with which of the following parties? LLP should file its statement of account and solvency with registrar of the firm. LLP should file accounts and solvency with registrar and with the registrar of cooperative society. What is the right answer? Hanji class, what is the right answer? The LLP should file its statement of account and solvency with which of the following parties? With registrar of the firm, registrar, registrar of cooperative society. The right answer will be 7th. A is the right answer. Okay class, A will be the right answer for this question. Now, the next is which of the following parties in LLP is responsible for fixing the auditor remuneration? Tell me. Which of the following parties in LLP is responsible for fixing the auditor remuneration? It may be fixed the registrar may fix the auditor remuneration. Designated partners may fix. The auditor remuneration get decided as per the procedure laid down in agreement, because C class, in partnership, the partnership deed is there. In the company, memorandum of association, this is there. And this is your agreement. LLP agreement. Tell me, which of the following is the right answer? Which of the following parties in LLP is responsible for fixing the auditor remuneration? The registrar may fix. Designated partners fixed according to agreement. So in this one class, the right answer will be D will be the right answer. Okay, D will be the right answer. No, Sabyasachi ma'am, the right answer will be D. Okay, now, which of the following parties LLP can remove the auditor from their office? First, registrar can remove, partners can remove. LLP agreement have no provision for removing the auditor. The consent of all partner is necessary, and both B and C is the correct one. Who can remove the auditor from their office? Again, that is important one. So class, for this one, the registrar cannot participate in this one, but B and C, this is the right answer. Okay, D. Okay, D will be the right answer. Now, what is the maximum number of partners in LLP? 100, 250 or unlimited? Tell me class. This is again very much important question. If I talk about the company, so in the company, private, public, one person company, private 2, 200, public 7, unlimited, one person 1 and 1. So that is a minimum and the maximum number of partners. Okay, if we talk about the directors, in the private 1, in the private 2, 15, public 3, 15, 1% 1, that is 15. So this is minimum, this is maximum number of directors. So if we talk about the LLP, the minimum is again 2, the maximum is unlimited. So this is the right answer. Okay, this is the right answer for this question. Okay class, now in the case of LLP, the partners are the agent of LLP, other partners both A and B, and none of the above. Tell me. Tell me class. In the case of LLP, the partners are the agent of B is not the right answer, because in partnership this term is there that partners are the agent and the partners are the principal, but in LLP the partners are the agent of, that is none of the above. Okay, because for the, if any one partner have done the wrongful act, for that thing nobody is liable. Common seal is mandatory for company. Tell me. Common seal. Common seal is mandatory. So it is also just like the company. In the company it is not mandatory, right? So that's why in LLP also that is not mandatory. Okay? Because in 2015 the act has been changed. So D is the right answer. D is the right answer for this question. Okay? Now class, true and false you have to do. It is mandatory for LLP to have a common seal. The answer will be no. Because just like company, from 2015 the common seal is not mandatory. Is that okay? Next, LLP is not a body corporate. That is absolutely wrong. Executing an LLP agreement is discretionary, because LLP agreement is the most important document. It is discretionary. So, third one, what is the right answer? So, executing an LLP is discretionary. The answer is absolutely yes. All partners have unlimited liability. Answer is yes. LLP is governed by Partnership Act. Answer is no. It is governed by LLP Act 2008. Every partner of LLP is the agent for the purpose of business, but not for the other partners. Third is false. Why, Sabyasachi ma'am? Tell me class, what is the right answer? Okay. Sixth is false. 6 false. Exactly. LLP is incorporated for the charitable purpose and for the business. The answer is no. It is only made for the business. Foreign national can be become the partner of LLP. The answer is absolutely right. Any person can become the partner. Okay. No, Sabjati ma'am. No. This is not right. Because in the partnership act, this theme was there that the partners are agent, the partners are principal. But in LLP, ma'am, it is not there. In LLP, suppose if one partner have done the wrongful act, for that wrongful act, other partners will be not liable. Okay, this is the basic theme. Okay. So class, that's all for today's class. Thank you so much for attending the session. And this is your victory batch, single batch. You can take single batch also, and you can take the CIB ka Mahapack also. Okay. Thank you so much.